Thanks everyone for joining us today. As it shows, we're going to be talking about some of the top things you need to know in 2024. A lot of things happened at the end of 2023, and we're seeing some trends that are kicking up for this year, and we want to make everybody aware. Just our quick disclaimer, this presentation is for educational purposes only. It doesn't on its own constitute legal advice or create an attorney-client relationship. We'll have some information at the end on contacting us if you have some specific questions, and we will move through this rather quickly, as you all know, because our time is limited today. As noted, I'm one of the attorneys with myHRcounsel, and we're going to just hop right into the agenda. So we're going to talk about pay transparency and pay equity. Again, these are big issues that are going to be kicking up in 2024. Use of artificial intelligence, also known as AI, joint employment, balancing your workforce, and then we'll finish up with some cannabis law information. These are topics that you might already be working on. These are things that you might already be aware of or that your employees are asking about, but we just want to give some summary information on that today. So let's start off with pay transparency. What the heck is it? Well, it's the practice of sharing compensation information with current and prospective employees. Pay transparency can include pay ranges, how pay is determined, or the pay of individual employees. The purpose of the pay transparency movement, and then some of the laws we'll discuss shortly, is to promote fairness and reduce pay disparities based on things such as a person's age, race, national origin, gender, things like that. And a lot of places have laws that relate to pay transparency. So really, regarding those laws, it depends on where you're located. Some states and localities have pay transparency laws, some do not. The laws vary in their scope, but generally they require employers to provide applicants the salary range for a posted position at a specified point during the hiring process. Some of the laws require an employer to provide applicants and employees a salary range of a position only upon request from the applicant or when the person's changing jobs. Some laws require a salary range in a job posting, and some laws may require employers to report pay data to government agencies. There are some interesting generational differences when it comes to pay transparency laws. For example, the baby boomers and Gen Xers don't like pay transparency. They think, hey, it's nobody's business what I'm paid, and I don't care what anybody else is paid. Younger people in your workforce, whether it's Gen Y, Gen Z, or Gen Alpha, they love pay transparency. They want to know what everybody's being paid. Some of the states or locations that have pay transparency laws are California, of course, New York City, of course, then states like Illinois, Colorado, Connecticut, Maryland, Rhode Island, Washington. Some of the aspects that can be included with pay transparency are prohibitions on employers asking about an employee's previous pay. So that would be states like Alabama, Massachusetts, Missouri, and Oregon. Why this matters to you, this issue is coming up not just as a cultural practice amongst groups of employees based on their age, but as laws, as we had just discussed. Depending on where you operate, you may be under a legal obligation with this type of data. So reach out to us if you have questions on your specific location. Another big issue that we're seeing for this year is pay equity. What is that? That's a legal concept that involves paying employees equally for equal work, regardless of other factors such as a person's age, race, gender, national origin, religion, or other factors that are not really related to the job. There are federal and state laws that require pay equity. For example, the United States government, or the feds, Congress passed a law in 1963, the Equal Pay Act, that prohibited different pay for men and women. So there's been a law on the books federally for over 60 years regarding pay equity. 42 states also have pay equity laws, but the issue is that even with these laws in places, pay equity isn't always a fact that comes into the workplace. But we're seeing that more and more agencies are going to be focusing on this as we go into 24. to help lower the risk of pay equity or pay discrimination claims, a lot of employers are choosing to do what's called a pay equity audit. And that's actually a fairly involved process where an employer would hire an outside consultant who specializes in pay audits to look at who's being paid, how much, why they're being paid. That can be a way to help reduce risk and also develop pay ranges for certain positions. It also tends to focus on non-protected factors, and it focuses instead on things like your education, your experience, your skills, and it moves employers away from maybe some unintentional bias in pay practices. But again, that's something we'll be keeping an eye on this year. Another big issue, and we've spoken on this before, but we'll probably continue to talk about it, is use of artificial intelligence, and specifically, what does that mean as it relates to employment law? So artificial intelligence, or AI, is the science of making machines that can think like humans. AI can process large amounts of data in ways that a human cannot and at a speed that a human could not. The goal of AI is to be able to do things such as recognize patterns, make decisions, and make judgments like humans. But the question is, so, okay, how does this relate to employment law? Well, the issue that comes into play is more and more employers are now using software that incorporates AI to screen applicants. That means the machine is taking the first run through people that apply for a job with you, not a person in your HR department. The risk with that is that you can get into an area where the AI has unintentional biases built into it. For example, the EEOC is in the process of looking at algorithmic fairness. What does that mean? Oh, Kim, can we see the next slide? That means they're looking at scrutinizing software to make sure that there's not bias built into your AI that you're using and hiring. The EEOC, again, that's a federal regulatory agency. They're concerned about disparate impact in hiring, meaning certain groups would be impacted adversely by use of AI. The laws that can come into play could be Title VII of the Civil Rights Act, which prohibit discrimination based on race, sex, religion, and national origin. There's disability concerns, there's age discrimination concerns, and sexual orientation concerns. Some of the areas where AI can create problems for employers are if it's using keywords, if there's a chat bot, if there's a video interview review, if there's a job testing software where applicants demonstrate their skills. That's what the EEOC is looking at. So they are really coming down hard on AI and saying, if you violate any of these anti-discrimination laws with your AI software for hiring, it's a strict liability issue. As an employer, you're automatically liable. You're on the hook. They can fine you. There's no wiggle room. There are no mitigating arguments. So if you are using this technology, you want to talk to your vendor about their software. Have they done an anti-bias analysis on it? You may even want to, if you can get them to do this, look to shift liability onto them, your vendor, meaning if they provide you with a product where then later down the road you've used the product and you get tagged by the EEOC or a state equivalent because they feel your software is biased. Another huge issue that we've been talking about, and you're going to hear more about in this month and definitely in the next month, is the new joint employer rule that's been put out by the National Labor Relations Board. And that looks to make any companies that have any type of relationship together both liable for any type of employee issue that might come up. So under this new rule, two different companies might be considered joint employers if they have an employment relationship with common employees. Think of a franchisor or franchisees, or maybe a staffing service, and those two employers share or co-determine at least one of the essential employment terms and conditions. So that means that under this new rule that they've put forth, a business is a joint employer if it has the right to exercise control over any of certain factors that they have listed out, even if the only way it could exercise that control would be through an intermediary, meaning as somebody at the other worker's site. So what are the factors that they will be looking at with this rule? They're going to look at wages, benefits, and other compensation, hours of work and scheduling, assignment of duties, supervision of the workers, the work rules, the length of employment, and then the working conditions regarding health and safety. So why this matters, again, if you're a staffing firm, if you're a franchisor, if you're a franchisee, or if you ever use workers from a staffing firm or an outside placement agency in your business, if so, and if this rule is finally implemented, any of the factors shown on this slide could make you responsible for another company's employees. Where this is at right now is this rule is currently being appealed. A number of groups have said, hey, we don't like this, we're pro-business, we're going to take you to court because we think this rule is going to mess things up. So the implementation of the rule has been delayed until February 26th of 2024, so next month. It might be delayed longer based on the outcome of this litigation, or it could take effect on that date. So the February 26th is a date to watch with this issue. We are keeping an eye on it, so stay tuned. Another big trend we're seeing for 2024, and that we are getting some questions from clients regarding, is how to balance out your workforce. That means, where are your workers going to be located? Are they all going to be in person? Are they going to be all remote? Or are you going to do a blend of both? So some employers with all in person are requiring that everyone now come into a work location. I mean, that wouldn't be applicable to those employees or employers who need people to go out and work at different places, such as if you're in construction. This kind of relates more to fixed work site type of businesses. A lot of employers feel that workers get more done when everybody's there. There's more collaboration between employees. The employers can also monitor everybody more easily to make sure the work's getting done. Going back to our generational point before, our friends baby boomer and who are baby boomers and Gen Xers, they're okay with it and most prefer it. A lot of them really like being in person. That's what they're used to. The younger folks in Gen Y, Gen Z, and Gen Alpha, they don't like it. They don't want to be in your office. They want to be at home. These are general trends that we're seeing. All remote is very popular with like technology and customer service companies, no main office. We see some of that too. The hybrid is probably what we're seeing the most of. So there's a mix of in-office and remote. Also included a lot of times is a mixed weekly schedule. So somebody will be in the office 2 or 3 days a week, then at home the other days. That's really common. And I think a lot of employees do like the hybrid model. So regardless of what you're going to end up doing, if you're going to do, for example, all in person, do you have enough space for everybody to come back to work if people have been gone? Do you have enough furniture? Is there parking? How long are you stuck in your lease? If you have anybody working remotely, you need to have a remote worker agreement with each individual. That's something that we talk about a lot and get questions from and have a document that covers. And also with any remote workers, you need to register to do business in the state where your people are actually performing the work. So you got to pay taxes. The employees are going to be covered by the employment laws where they're actually physically performing the work. And you also, depending on where your employees are located, you may need a business license from the city that they're located in or the county where they are actually doing the work in order for you to operate there. So there's some additional challenges and administrative pieces for an employer that has any remote workers. And then lastly, can we go to the next one, Kim? And then lastly, well, I'll just start. We're going to talk about cannabis. There's going to be more state legalization to look at. You're going to need to consider testing restrictions. The federal government is surprisingly looking at rescheduling cannabis, which would have a huge effect. And so we'll talk a little bit more about this in detail. So cannabis, that's kind of a more popular term these days, also known as marijuana, weed, grass, the devil's lettuce. There's a lot of different names. We all know what it is. Recently, the states of Missouri, Minnesota, and Ohio have done some form of advanced decriminalization or legalization of cannabis. If you're working in a state that has lightened up on cannabis, you need to really look at what laws apply for employment and hiring. Even, for example, in California, you can't ask workers about their use of cannabis outside the workplace, and you can't use hair or urine tests. Some industries like construction are excluded, and then some federal jobs are excluded from that rule, but that's California. In Minnesota, even with their new law, testing job applicants for cannabis use is not allowed unless the testing is required by the state or federal law, or there is a argument that an employer can make that the person would be in a safety sensitive position. The law, of course, doesn't define that for you. So there's some gray area where you may need some guidance with that. We talked about rescheduling for a second. If that were to actually happen, that would mean that the federal government would move cannabis from Schedule 1, controlled substance, which means no accepted current medical use, to Schedule 3, which means a lower to moderate risk for abuse and dependence, and also some medical use. Now, if the federal government moves cannabis from Schedule 1 to Schedule 3, that's going to create giant sweeping changes in employment law. It's going to affect your workers with commercial driver's licenses. It's going to affect other aspects of the transportation field. So that could be a really massive upheaval that we're watching for 2024. Also keep in mind that this is an election year, so there are going to be a lot of law changes in different states to favor certain constituencies to try to get an outcome, basically. So that's a lot of the reason why people think marijuana is in play at the federal level this year, because it's a general election year and there are individuals who are interested in having marijuana rescheduled. So we'll see what happens with that. As always, if you have any questions, let us know. Compliance is not optional on these issues. You can always rely on our advice to get you through a situation. If you are a client, you have questions on any of the information presented today, send us a ticket. If you are interested in becoming a client, we've got our contact information on the screen. Thanks everybody for listening today. We very much appreciate it, and we will see you soon with another myHR Minute.